I got a visit personally from an FBI agent in my offices in 2004. The agent delivered to me a letter, and the letter demanded that I hand over a lot of information about one of the clients of the company. It caused me great concern because the first thing that sort of really shocked me was that this was not a court order. This was a letter from the FBI signed by an attorney. And it seemed to me that it was not a legal order, and it seemed to me that it was pretty clearly not constitutional on its face. The FBI had not gone to court. It had not proven probable cause before a judge, and so the other problem, though, with the letter was that it told me that I could never tell any person that I had received the letter, which pretty obviously precluded me from speaking to a lawyer or to anyone else in my company or to anyone about it. And I was quite afraid to disobey the letter. But after I took a bit of time and thought about it, I decided, we always have the right to speak to an attorney. So I called my private attorney. We then went together to the ACLU, and then we ended up embroiled in this really long court saga, which lasted almost 7 years.
Which also involved 4 librarians from Connecticut, right, who were also given an NSL, National Security Letter, when they were asked for information about Internet users and the library systems of Connecticut.
Yeah, somewhere about 2 years into the case, the librarians became co-plaintiffs along with me, although at that time they were just known as Connecticut Doe and I was New York Doe, and we didn't know who each other were until many years later. But yes, the librarians had also received a national security letter in Connecticut for library patron records, also a very upsetting issue. The case, though, it was an interesting case because it resulted in the national security letter provision of the Patriot Act being ruled unconstitutional twice. And actually, recently, I think, in California, in the Ninth Circuit, there was a similar ruling. The problem was, though, we were never able to get to the Supreme Court to get a final binding ruling that would affect the whole country. And to be honest, it felt to me like the government wasn't really acting in good faith, that when it seemed like they were going to lose, they would back out of all these cases. It seemed to me that they were afraid to have the Supreme Court rule on the issue itself.
Why is this important?
It's really important because what's at the heart of this matter here, the 800-pound gorilla in the room is warrantless wiretapping and surveillance of Americans without any suspicion of wrongdoing. As we've heard with the revelations from Edward Snowden, this is a very widespread problem. And what I started to get a sense was happening back in 2004 was that essentially the rule of law was being eroded by a combination of the Department of Justice acting without proper checks and balances, overseeing what they were doing, by evading the courts, and by evading the court oversight, and by issuing these national security letters themselves, they were able to gather huge amounts of information on Americans. And then also by putting everyone under gag orders who received them, they were able to prevent anyone from talking about what was happening.
If you even talk about getting a national security letter, you face 5 years in prison.
Right.
If you even mention it to a coworker.